Hello folks, good evening class. Online class is the AV working. Online class AV is working, no? Okay. So, good evening class. We will be starting with polity and governance current affairs. The topics that we will be discussing are anti-defection law and merger clause constitutional validity. First topic we will be discussing is this. Okay, write this down. Done? Okay. First, this keywords you look at this. Anti-defection law, merger clause and constitutional validity. So, recently what has happened means your 7 AAP members have joined your BJP. Okay. Now these members, okay, it is about 2/3, right? Out of 10 members, 7 members join. Now these members are the MPs. They are telling they should not be disqualified because of your merger feature. Okay, merger is telling what? That 2/3 of members are joining means then you can't disqualify the members. But here what is the question means? Should the original political party undertake the merger or just the legislators do the merger? If it is the original political party that is merging with another party, then that comes under your 2/3 of members merging with another political party. If only these legislators are the ones who are, okay, joining to a particular political party, then that will not be having the benefit or your, let's say, the disqualification will not happen based on your merger. Okay, so in this case 7 MPs of Aam Aadmi Party have joined BJP. They are seeking protection under your merger clause. So what is this merger clause? 2/3 of members. Okay, if they join a political party, then they will not be disqualified under your anti-defection, which is in the 10th schedule. When was this added? In your 52nd constitutional amendment. Okay, why? In order to create political stability or to prevent horse trading. Okay, Ayaram, Gayaram scenarios. So here the core question becomes, can only legislators merge or the original political party merge? Okay, read on up until here. Done? Shall we move ahead? Next. So what is this anti-defection? It was added in the 52nd Constitutional Amendment Act of 1985. You have to put an asterisk next to it. It is extremely important. This is in your 10th schedule. Okay. This became effective from your March 1986. Why was your anti-defection law created? Means in order to create political stability so that people will not keep shifting from your political parties, okay, for your personal benefits, and to curb the horse trading, okay, which is otherwise called as Ayaram Gayaram. Okay, write this down. Done. Next, let's see the historical background of your anti-defection. The whole point started in 1967 when there was lot of defections. Okay, in your 1967 to 72 period, more than 2000 defection were recorded in your 5 years, especially when your Haryana, okay, MP Gaya Lal, he shifted parties, okay, in 3 times in a single day. This was where your Ayaram Gayaram concept came in, where they felt like there is political instability where people are doing this. So in order to bring about a sense of political stability, reduce your horse trading, in 1985 they introduced 52nd Constitutional Amendment Law, or your anti-defection, as the new schedule. Okay. We'll move ahead. Now, 52nd Amendment was 1985. It introduced anti-defection law, 10th schedule. Okay, this much we have spoken. In the same aspect, there are two more things you have to see. One is split of party and merger of party. Split means 1/3 of members. When they split from the party, okay, then they are also protected against your defection. Merger is 2/3 of the members. So these both were sort of protection under your 52nd Constitutional Amendment. Who will decide with regarding to the disqualification? Means that will be the presiding officer. Speaker in Lok Sabha, chairman in Rajya Sabha. Okay, presiding officer is the one who will decide on the disqualification. Another important act is your 91st Constitutional Amendment Act of 2003, wherein here I told you the protection was between split and merger. They removed the split provision. Split is 1/3 of members. Okay, so split was removed and they retained only merger, which is 2/3 of members. So this was further strengthened in your anti-defection. 91st Constitutional Amendment to strengthen your anti-defection. Split became the loopholes that many political parties were using. Okay, in the same 91st Amendment, they also told that Council of Ministers should not exceed 15% of the total House ka strength. Next. So, 52nd Amendment spoke about split, merger. Final, who is the one who will decide on the disqualification? That is presiding officer. 91st Constitutional Amendment, split was removed, only merger continues, and presiding officer is the one who will look into the disqualification of cases. On what grounds can you disqualify a person? Okay, First and foremost, voluntarily giving up a membership. Now, voluntarily giving up a membership does not mean that the person has to only voluntarily give up membership, but also his conduct also determines, okay, whether this particular person has to be removed or not. So, conduct of the member also matters with regarding to your giving up of membership. For this, okay, they don't have to particularly make sure that this person will give the, okay, resignation, then only we can take it. Second thing is violation of party whip. Let's say your party whip means, understand it this way, this is one example, party ABC. There will be called as polity, okay, wherein there is something called as party whip. Your party will tell this whip, tell the members as to who you have to vote, okay, and you should not abstain from voting, you should not vote against what party whip has told. If so, then you will be brought under disciplinary actions of party whip. Based on, see, just because someone has voted against your decision doesn't mean immediately that person will be disqualified. The decision will be based on the presiding officer. But your party whip, whatever it tells, your members have to follow, okay. So they shouldn't vote against the party direction nor abstain, which means not take part in voting, okay. So independent member, if he joins a political party, he also will be brought under disqualification. Nominated member within 6 months, if they join a political party, no issue. After 6 months, if they join a political party, then they will be disqualified, okay. Now, what are the exceptions that are there? Exceptions means on what basis, if things happen, you will not be disqualified. 52nd amendment, we had split and merger. 91st amendment, we removed split, we only have merger. So what is the feature? Member will not be disqualified. Look at the keyword here. If original political party merges with the party and at least 2/3 of members of legislature party agree for the merger. Here two things are important. One is original party should merge with another party. In that original party, at least 2/3 of members has to agree for the merger. In our case, 2/3 of the members of the legislature party joined. The original party, your founder Arvind Kejriwal, he was not the one who did the merger. So here is where the debate comes for your 7 AAP members. Also, there is a twin test. Why is this twin test needed? In order to make sure that the merger clause should not be used as a loophole. Because only if your legislature party is doing this, it is nothing but mass defection. So in order to prevent from this loophole, they have told that twin test has to be conducted. What is first? Both these. Test 1 plus test 2 only will give your safety with respect to your or protection regarding merger. What is test 1? Original political party should be merging, not just legislature members, not just MPs. Second thing is at least 2/3 of members should agree to this merger. This plus this should happen. In Aapka case, only this has happened, this has not happened, which would lead to their disqualification scenario. Understood? You can write down if you want. Done? with regarding to presiding officer. Let's say who will decide on the disqualifications? Lok Sabha, it is the speaker. In state legislative assembly, also speaker. Rajya Sabha, chairman of the house. Legislative council, also chairman of the house. Now in case if the chairman or speaker, okay, voluntarily will resign from a political party. Why? Because they are made into speaker or chairman, means that will not lead to disqualification. After their role as speaker or chairman ends, they can again join back to the political party. Okay, so why are they resigning from their seat? It is only to make sure that there is neutrality. Let's see some judicial interpretations. First one is Hito Olhahan versus Zakhilu case of 1992, where they told the speaker's decision with regard to anti-defection is subject to judicial review if it is based on malified constitutional violation or procedural irregularity. Okay. Next, Ravi S. Naik versus Union of India pe, they told that conduct of a person may amount to voluntarily giving up membership. We saw in which cases your removal can happen, defection can happen. Next is formal recognition from party is not necessarily called as disqualification. Last, Keshan Megchandra Singh versus Speaker of India pe, they have held that speaker should decide the disqualification within 3 months. It is suggested, it is not bound. The speaker does not have a specific timeline, okay, to debate on this issue. Now this is important. Remember the twin test that we spoke before, that was told in your Subhash Desai case, wherein original political party and legislature, these are two separate entities, not same entities. Aapka case only legislature party has joined, original party has not joined. Here in twin test they are telling this plus this should happen. Legislature party cannot decide a party merger. Okay, so twin test should be done. Next is Paddy Kaushik Reddy 2024. They suggested that there should be reforms in anti-defection process and re-examination of speaker role is needed because they are not bound by particular timeline. Okay, write this down. Next, these are few of the committee recommendations with regarding to anti-defection. First one is Dinesh Goswami committee, which has told that president or governor should decide the disqualification cases and it should be based on the binding advice of election commission. Next, law commission, they have told anti-defection keep it only for 3 things: confidence and no confidence motion, money bills, and party stranglehold on legislators. Okay. Next is your election commission and judicial views. In order to deal with your anti-defection cases, create independent tribunals, okay, and create the decision within 3 months. Don't give it to your speaker, but separate tribunals, let it be created. Okay. So, your Aapka case in present, MPs are claiming we have protection under merger clause because 2/3 of us joined, okay, and against is original AAP party has not merged with BJP, only legislature party has merged. According to Subesh Desai ruling, twin test must be satisfied, but here in this original party has not been merged, so in twin test this fails. Okay, so this will lead to defection and disqualification is what they are mentioning. So in simpler sense, 10th schedule is your anti-defection brought about by 52nd amendment, which speaks about split and merger. Here 91st amendment pe split was removed, merger continues, COM has to be 15% of the strength of house. Okay, merger has to be through your twin test, 2/3 of members plus original party has to be merged. Okay, so who will decide the disqualifications with anti-defection? It is the presiding officer. Okay, then we saw the 52nd amendment, split and merger. 91st is only merger, and this is subject to judicial review. If there is any malified constitutional issues, procedures are not followed in that case. Okay, now let's see a possible prelims question. With reference to anti-defection law in India, consider the following statements. The anti-defection law was introduced through 52nd Constitutional Amendment Act of 1985. Statement is correct. Legislature party alone can validly claim protection under merger provision without any merger of original political party. Legislature party alone cannot do this. It is a twin test, legislature party plus original party. Third, the Speaker's decision under 10th schedule is subject to judicial review. Yes, on the grounds of malified constitutional procedurality. The provision related to split by 1/3 of members was removed by 91st Constitutional Amendment Act. Correct. They are asking 1, 3, 4. Excuse me. A, 1, 3 and 4 only. Second topic is National Panchayati Raj Day of 2026. Read this down. Done? So look at this. National Panchayati Raj Day has always been celebrated in India on 24th April 2026. Okay. Why we celebrate on this day? Because that day is where your 73rd Constitutional Amendment Act of Panchayat Raj Institution was brought about, which marks 33 years. 24th April. Okay. The Constitution has granted a constitutional status for Panchayat Raj. Now, if you see what is the status or your theme for your National Panchayat Day, it is Sashakt Panchayat Sarvangeen Vikas. Okay, which means holistic Panchayat development. Okay, this is what they are trying to tell. By this, they are also trying to align with your Vikshit Bharat 2047. Now, if you see with regarding to how did your Panchayat Raj institution come into picture, see, first and foremost, 1992 73rd Constitutional Amendment was brought in. It came into force 24th April 1993. Okay. What were the 73rd Amendment there means? This 73rd Amendment added Part 9 of the Constitution, that is from Article 243 to 243O. It added 11th schedule with 29 subjects given to the Panchayat Raj. Okay, and it came into force on 24th April, given a constitutional status. Okay. So first it was observed in 2010 under your Prime Minister Manmohan Singh. From that day onwards, 24th every year, April pay, it is held. What is the concept of your Panchayat Raj means? Decentralization and grassroots level democracy. Okay. Best panchayats are also awarded on these days. Now, if you see what and all 73rd Constitutional Amendment Act has, first of all, Part 9, Article 243 to 243O, it speaks about 243A Gram Sabha, Constitution of Panchayat, composition of Panchayat, a reservation of seats where 1/3 of seats are given to women. Duration is 5 years. But if say a panchayat is removed before 5 years, then elections has to be conducted. But if it is only 6 months of time, then new elections only will happen. The newly constituted panchayats will only survive for the remainder period of time. 243 K tells state election commission has to be conducted, has to be created for conducting elections for panchayat and municipality. 243I is creation of state finance commission for devolution of funds. So 11th schedule has 29 subjects such as agriculture, land reforms, minor irrigation, rural electrification, animal husbandry, etc. Okay. So in our Panchayat Raj system, we have a 3-tier structure. First tier is Gram Panchayat, which has importance of Gram Sabha. Second level is the intermediate level, Panchayat Samiti or your Mandal Panchayat. This is not mandatory or optional. Optional in the sense, if any place has population less than 20 lakhs, then you can skip intermediate level. Next is district level at Zilla Parishad. So these two are compulsory. Whereas this is, if it is less than 20 lakhs, you don't have to create Panchayat Samiti. Okay. Next, elections. All the members of Panchayat are elected through direct elections, whereas chairperson at intermediate and district level will be indirect elections. These elections will be conducted by State Election Commission according to 243K. Now if you see for reservation, SC, ST have a reservation based on their proportion to population. Women have 1/3 of reservation, okay, which is also included in the SC, ST. So 5 years their term is, but they can be removed before that also. In that case, new panchayat will be constituted only for remainder period. But if it is below 6 months of time, then it will not be conducted. Fresh elections will go on. So next is State Election Commission. What it will do? Conduct election to Panchayat Raj institution. It maintain electoral rolls for your Panchayat Raj institution bodies, and also it is appointed by your governor of the state. What will the State Finance Commission do? Means is constituted at the end of every 5 years by state government. It will review the financial position of PORI and it will recommend the distribution of taxes. Next, if you see, we have 2.5 lakh plus panchayats where more than 24 lakh representatives are there. Of them, at least 49% and above are women representatives. 29 subjects are there in 11th schedule. In the 15th Finance Commission, 2.36 lakh crores has been granted for your rural local bodies, and 16th Finance Commission is telling for enhanced. Okay. Next, look at the government initiatives. First one is Swamitwa scheme. So in Swamitwa scheme, what it is means, they will map the villages, okay, in order to make sure that property cards are given to the rural households. Next, E-Gram Swaraj, this digital government platform, okay, to showcase as to where your funds are being utilized, managed. Rashtriya Gram Swaraj Abhiyan, okay, which is nothing but you are training the Panchayat Raj institution representatives. Sabasar, okay, which means your languages, okay, through your Bashini portal. Okay, where it is converted into different regional languages. Next is Gram Urja Swaraj, that is creating renewable energy usage in Gram Panchayats. Next is Meri Panchayat app for citizen participation. And lastly, model friendly women Gram Panchayats, so that one particular Gram Panchayat will be fixed in such a manner that will serve as a let's say a model for all the other panchayats. Next is Sashakt Panchayat Netri, that is leadership training for your women representatives in Panchayat Raj institution. Okay. Next, look at this. So Article 40 also promoted. It's one of the Gandhian features for your decentralization. Okay, Article 40 tells state shall take steps to organize village panchayat. So if you see between your panchayat and municipality, panchayat 73rd amendment, municipality 74th, it is in 11th schedule with 29 subjects. This is 12th schedule with 18 subjects, 243 to 243O, 243B to 243ZG. It's for rural areas, that is for urban areas. Okay. So we have seen amendment of Panchayat Raj Institution, 73rd Amendment, Part 9 of the Constitution, 29 subjects. We'll see one prelims question. With reference to Panchayat Raj system in India, consider the following statements. 73rd Constitutional Amendment added Part 9 to the Constitution, correct. 11th schedule contains 29 subjects related to Panchayat Raj institutions, correct. State Election Commission conducts elections to panchayats in the 243K, correct. All states are constitutionally mandated to establish 3-tier panchayat system including intermediate level. See, all states and mandated. No. Population is less than 20 lakhs. Can omit block level panchayat. So correct options are 1, 2 and 3 only. Next topic, right to safe travel on national highway under Article 21. Write this down. Done? Okay. So what it is means, see, your national highways, okay, they contribute to only 2% of your roads, but they contribute to 30% of your deaths due to accidents, and these accidents are preventable. So which means people are not doing their duty properly. So when you can save lives, okay, because your Article 21 tells what? A right to life and personal liberty. So When you can save the life because of provision of safe travel, then that comes under your Article 21 if you do your job properly, because these accidents are preventable. Okay. So why is it in use? Supreme Court has declared national highways safe travel is part of your right to life under Article 21 of the Constitution. Okay. So right to life is protection from, look at the keyword, avoidable road accidents, and state is supposed to have a positive obligation, which means you are mandated to do your duty properly to prevent avoidable deaths. Excuse me. So what is Article 21 of the Constitution? No person shall be deprived of his life or personal liberty except according to procedure established by law. So the broader interpretation, right to life means right to live with dignity, a right to a clean environment, a right to safe travel. All these are all part of your Article 21 added through various judicial interpretations. So Supreme Court has told that states must go beyond passive non-interference. It should not just tell, yes, this has happened, death has happened, it is not our fault. No, you have to see preventable death accidents has to be done, because that is the duty of state. That is part of your Article 21. If you don't do that, then that is breach of Article 21. It also tells that national highways contribute 2% of total road network, but they contribute roughly 30% of road accidents. Okay. So this shows that there are a lot of accident prone regions. What are some of the directions given by your judiciary? If you see, now let's say if this is highway, on the sides they will create your drains, okay, all these things. No, they have told as of now whatever is there in the highways, no new dabas has to be created, no commercial establishments, existing ones can be there, no new things has to be created like dabas, eateries or commercial establishment within highway right of way, which means this junction. Okay. And heavy vehicles should not be parked on the roadway because it creates a blind spot. They should only be placed near your designated laybys. And also heavy vehicles also have to follow certain aspects as to only on particular areas is where you're supposed to park. Okay. So how exactly this has to be implemented means the district magistrate have to remove illegal structures from highways, and they have to do it within 60 days of the order, and no trade license will be issued without NHIA clearance, and most importantly you have to maintain that the right of the way that let's say new institutions or new commercial entities should not be created. Okay, and the creation of a district highway safety task force has to be there in order to monitor the safety in every district and to make sure it is seeing the compliance. So what is right of way means land reserved along or around the highway for your construction, widening, these kind of things. Lay-by means where your vehicles can stop by the highways. So if you see, there are two important bodies that we will see. One is your NHAI and one more is Ministry of Road and Transport. NHAI means National Highway Authority of India. This is what will do the development and maintenance of national highways in India. Next is Ministry of Road and Transport, which will see all the oversight of India's road transport sector. Okay, we'll see one prelims question. With reference to right to safe travel on national highways in India, consider the following statements. The Supreme Court has held that right to safe travel on highways is part of Article 21 of the Constitution. Correct. National highway constitute nearly 30% of India's total road network. No, 30% is death due to accident, 2% is road network. Heavy commercial vehicles are allowed to park on paved shoulders of NHAI only at designated laybys and wayside amenities. Correct. NHAI functions under Ministry of Home Affairs, not under Ministry of Home Affairs, Ministry of Road Transport. So correct options are 1 and 3 only. Next, Panchayat Advancement Index. Done? So Ministry of Panchayat Raj has released something called as Panchayat Advancement Index for 2023-24. What does this means? It is to assess how the 2.5 lakh panchayats are performing in India. Okay, this is the world's first nationwide framework for measuring panchayats performance. How many panchayats were added? 2,59,867 gram panchayats. Okay, what are they trying to do means 17 SDGs, okay, are reduced into or clubbed into 9 local themes. So what is this Panchayat Advancement Index means? It is launched by Ministry of Panchayati Raj, okay, where it covers gram panchayats and local bodies. Why exactly it is done? To see how the rural development work is done, grassroots governance, that is people's participation, how is it, and localize 17 SDGs into 9 local themes such as poverty, health, education, okay, these aspects. So 17 SDGs are converted into 9 localized SDG themes. What are those if you see? Poverty, free and enhanced livelihood, healthy panchayat, child friendly, water sufficient, clean and green, self-sufficient infrastructure, socially just and secure, good governance, women friendly. If you see in which two aspects they are doing or performing well, it is poverty and health. Understanding? So what is the assessment? 2.5 lakh villages were covered. On total 150 plus indicators were seen. Okay, they were aligned with National Indicator Framework and National Panchayat Awards to see as to how exactly panchayats are performing. So it is in 5 categories. A plus category is called achiever if you score 90 plus. A category is called front runner category if you score between 75 and 89. B is performer category if you are getting 60 to 74. Aspirant category if you are getting 40 to 59. Just beginner category if you score below 40. Understanding? You want to write this down? Okay, write it. Next. In this, if you see, more than 97% of villages were covered, gram panchayats. And most important aspect, if you see, majority of the panchayats They were coming in the front runner category. 3,635 panchayats were getting front runner category. Best performing themes means your poverty free and health panchayat. Okay, no single panchayat has got into achiever category 90 plus and above. If you see, Tripura has got 80% of panchayats in the grade A or your front runner category. Kerala also has performed very well in health, water and governance. Odisha has been performing well across various localized SDG themes. Okay. So, what is different about your PI 2.0 means compulsory Gram Sabha has to validate this. Okay, ensure that grassroots accountability is there, and most importantly, community-led verification of data has to happen. Okay, so this data gets integrated into Union Ministry portal to provide real-time data. Okay, so this is data driven and citizen validated. Those are the two important things. Where will you use this PI means for Gram Panchayat development plans, resource allocation and Panchayat learning centers. So this is important for your SDG implementation into local themes. Let's look into one of the possible questions. With reference to Panchayat Advancement Index 2.0, consider the following statements. It was launched by Ministry of Panchayat. Correct. It localizes the 17 sustainable development goals into 9 themes of Panchayat. Correct. Panchayat scoring between 75 and 89 are classified as achievers. No. Achievers is 90 plus. No panchayat has got this. Gram Sabha validation has been made mandatory under the framework. Correct. Correct options are 1, 2 and 4 only. Next. Last one is Kaveri Water Management Authority. So, what is the issue here? So usually interstate water dispute is very common among your upper riparian and lower riparian state. Upper riparian and lower riparian. Which means the river is originating here. In this Kaveri case, Karnataka becomes the upper riparian, Tamil Nadu becomes the lower riparian. Kaveri is also called as the Ganga of southern India, and the fight among these two has been there since your colonial period. During colonial period of time, your Madras presidency had asked for higher amount of water because of its established irrigation system. Okay, but after independence, Karnataka said such kind of colonial laws will not be implemented. Finally, based on 2018 verdict, judiciary told one thing: water does not belong to any particular state. Instead, water is a, or your river water is a national asset. Okay. So, Kaveri Water Management Authority is created, which has told Karnataka to release Kaveri water to Tamil Nadu for May 2026. During distress period, okay, is where your fights between Karnataka Tamil Nadu usually happens. Based on your 2018 Supreme Court verdict, Kaveri Water Management Authority has told Karnataka to release water to Tamil Nadu. Okay. So, what is this Kaveri Water Management Authority? It is an interstate water dispute resolution body. So what is Kaveri Water Management Authority? Created in 2018. It is a statutory body which is headquartered in New Delhi. Okay, it is functioning under your Ministry of Jal Shakti. It is created under Kaveri Water Management Scheme of 2018. Okay. Which if you see, this is Karnataka, Tamil Nadu, upper riparian, lower riparian. It eventually drains into Bay of Bengal. So what is the composition of Kaveri Water Management Authority? Chairperson will be a senior engineer or IAS officer. There will be secretary or additional secretary who will be appointed by central government for a period of 5 years. Okay, there are part-time and full-time members. Also full-time members are your water resource expert, agricultural expert. Part-time members are your central government members. The basin state representatives of each state are the Karnataka, Tamil Nadu, Kerala and Puducherry. Okay. Now, these are the ones involved in this. What is the function of your Kaveri Water Management Authority? Means it controls the reservoir release from KRS Dam, Kabini Dam, Mettur Dam. Okay, the water is shared on particular basis. What is that basis? We will see further. So usually fights erupt using your distress when there is low rainfall or drought years among the basin states. Okay, they will keep monitoring and also they advise the basin states on micro irrigation so that it does not affect the states. Kaveri water also called as the Ganga of South India. Its origin is in Talkaveri in Brahmagiri Hills in Western Ghats of Kodagu district in Karnataka. It flows in the Tamil Nadu and drains finally into Bay of Bengal near Pumpuhar. So which are the basin states? Kerala, Puducherry, Tamil Nadu, Karnataka. If you see the tributaries of Ganga, left bank rivers are Harangi, Hemavati, Shimsha, Arkavati. Right bank are Kabini, Bhavani, Amravati, Noyal, Suvarnavati and Lakshman Tirtha. Okay, so these are some of the tributaries. Next, if you see, like I told you, colonial agreement was signed between Mysore Princely State and Madras Presidency where they got higher TMC of water. Okay, in 1892, 1924, again this was between your Mysore Princely State and Madras Presidency. 1956, after your Interstate River Water Dispute Act was brought in. Under Article 262, Parliament will adjudicate interstate river water dispute. 1990, Kaveri Water Dispute Tribunal was formed for fight between your Karnataka, Tamil Nadu, Puducherry, Kerala. 2018 is very important for your Supreme Court modified the award and declared that river water is a national asset, and Karnataka was given an additional of 14.75 TMC for drinking water in Bengaluru. Okay. CWMA was established, which is Kaveri Water Management Authority was established for this purpose. What was Supreme Court judgment in 2018? River is a national asset. No state can claim ownership. Bengaluru gets an additional drinking water of 14.75 TMC. Now in this, if we see how much states are getting, Tamil Nadu get 404.25 TMC, Karnataka 284.75 TMC, Kerala 30 TMC, Puducherry 7 TMC. Okay, Article 262, Parliament can adjudicate interstate river water disputes. Okay. Why your Kaveri Management Authority is important? Because it replaced ad hoc Kaveri River Authority and brought in a permanent mechanism. It does conflict resolution. It has sustainable water use, like I told you, micro irrigation in the basin states, and they take data driven initiatives, okay, which will be easier to do the water release data. So the constitutional and legal framework are Article 262, Parliament may adjudicate for interstate water disputes. Interstate River Water Disputes Act of 1956 provides for setting up of Water Disputes Tribunal. Kaveri Water Dispute Tribunal adjudicates Kaveri dispute, which was finally modified by your Supreme Court in 2018. So, the Kaveri Water Regulation Committee is more of analyzing water from across Kaveri basin in order to see how much the water levels are, how much the storage is, and how much inflow has happened. All this real time data is maintained. We'll see one prelims question from this topic. With reference to Kaveri Water Management Authority, consider the following statement. It was established under Interstate River Water Disputes Act of 1956. Correct? It functions under Ministry of Jal Shakti. Yes. The Kaveri Water Regulation Committee assists the Kaveri Water Management Authority in monitoring water data. Correct? Supreme Court in 2018 declared that states have exclusive proprietary rights over river waters. States exclusive proprietary river water, no. They told do not have. They do not have proprietary rights. In fact, the river waters are national assets. Correct options are 1, 2 and 3 only. With this, we have completed today's topics. Any doubts? Okay. We'll end the session.